There's another interesting development in the ongoing legal action surrounding Governor Roy Cooper's actions related to COVID 19. Superior Court Judge James Gale has issued a preliminary injunction against Cooper. It allows bowling alleys to reopen despite the governor's orders to keep those alleys closed. Joining us with expert analysis of this latest decision is Jon Guze. He is Director of Legal Studies for the Locke Foundation. Jon, we're going to get into some of the interesting ins and outs of this ruling, but first of all, your overall impression of Judge Gale issuing a temporary restraining order allowing North Carolina bowling alleys to reopen.
Well, I think the first thing that struck me about this is that I think what's happened here is, again, Roy Cooper didn't do the sensible thing. He didn't want to talk to people. He didn't want to try to compromise. You know, we talked last time about how he failed to take advantage, to do what he was supposed to do under the law and work with the Council of State on some of these executive orders. And here he's shown himself to be unwilling to work with business owners who have come forward in good faith, proposing ways they might reopen safely, but instead of responding to their suggestions or talking about why they wouldn't work, he simply says, I don't have to explain what I'm doing. The courts just are going to have to defer to me, and you're out of luck. And that was a mistake. And in this case, it's worked against him.
One of the interesting pieces, and we're going to go through several pieces of this 33-page ruling from Judge James Gale. One of them is that, as you might expect in this lawsuit, the plaintiffs come forward with a lot of different ways that they might try to win the case. The two that really struck the judge were the pieces of the North Carolina Constitution that talk about people having the right to the fruits of their own labor, and also the Equal Protection Clause. Were you interested to see that the judge really latched onto those and said, these are important pieces?
I was very interested to see that. The plaintiffs also raised the same objections to the way these orders were implemented that the lieutenant governor did in his lawsuit, and Judge Gale decided not to go there. He didn't say those were wrong, but he's not ruling on the basis of that yet. But he just looked at whether this case is likely to succeed on its merits under the Equal Protection Clause and the fruits of their labor clauses of the North Carolina Constitution. And the reason that's kind of exciting is that, like many state constitutions, North Carolina's constitution provides a lot more protection for economic liberty and liberty in general than the U.S. Constitution does. I don't think we've seen enough litigation that tries to defend these rights on the basis of state constitutions, so I'm delighted to see it working favorably here.
One of the interesting pieces of this for legal minds, for the people who are interested in the bottom line is the order says the bowling alleys can reopen. But a very interesting piece from the legal perspective is the standard of review, what the judge needs to look at to decide who's going to win the case. The governor argued, and his legal team argued for something he called the rational basis test. And the judge said, no, that's not the proper standard in this case. And he actually put forward what he called a reasonable relationship standard of review. Well, let's get into that a little bit. For those who aren't familiar with this, what are we talking about when we're talking about a reasonable relationship standard versus a rational basis test?
Well, to understand this, we really have to go back quite a way to the 1930s, when the U.S. Supreme Court, under a lot of pressure from the Roosevelt administration, decided it was going to have to stop using its power to strike down quite so many state and federal laws. And the way it decided it could do this was by creating pretty much out of whole cloth a legal dogma, which they called judicial deference. The idea is that the court should defer to legislators and to executives when it comes to the constitutionality of state action, unless there's simply no rational basis upon which such a law could possibly be upheld. As long as there's any possible rational reason why you could uphold such a law. So even if the state failed to come up with a rational basis on its own, the courts will often make up a rational basis for them and just say there still is a rational reason why this law might make sense, so we're going to let it stand. What this means in effect is that the plaintiffs always lose and the government always wins. I can't really think off the top of my head of a single case in which a court has struck down a law on using the rational basis test. The Supreme Court allowed a little room for other rights. For instance, things like First Amendment rights will be enforced more strictly. In fact, some rights, like the freedom of speech, is enforced by a strict scrutiny standard, but there's a lot of intermediate levels. They're all very subjective. And in this case, to the ordinary person, they might say, well, what on earth is the difference between a rational basis and a reasonable relationship? It's hard to say, but it's important because if you apply the rational basis test, the plaintiff loses. But if the state has to show some kind of reasonable relationship between what they want to do and some appropriate goal, then the plaintiff has a chance.
And you just alluded to it at the very end, that the bottom line is the rational basis almost always allows the government to win, whereas a reasonable relationship, the plaintiff could put forward some pathway of evidence that suggests that the plaintiff should win the case, which is what's helping the bowling alley owners here. As we move forward through this decision, basically, you alluded to this as well earlier, the judge is saying that the governor has not, as this process has moved forward, been willing to review what the bowling alleys said they would do to comply with his attempts to protect North Carolinians' health. That if the governor had reviewed the plan and said, no, your plan's not going to work and here's why, the judge might have been more differential to the governor. But the governor basically has said, no, we're rejecting opening bowling alleys. And once the bowling alleys came back and said, yes, but we're willing to do X, Y, and Z, the governor was silent and didn't even respond at all.
That's right. And not only that, after the case was filed and the bowling alley, the representatives for the bowling alley started presenting affidavits and information showing what other states were doing, why their proposed remedies would solve the problem. The state didn't even come forward with countervailing explanations of why they were wrong. Mandy Cohen didn't respond to specific requests for an explanation. So I think this is just another case of governor being a little too arrogant and not being willing enough to work with people and compromise.
And in fact, you mentioned Dr. Mandy Cohen. The judge does use some information from Dr. Cohen, but he doesn't use information really based on the latest proceedings in this suit. He uses information that she had presented earlier about her concerns and said, okay, well, here's what Dr. Cohen has said about why a business should not be able to reopen. Here's what the bowling alleys say they would do to respond, and they seem to be responding. And one of the things he mentioned specifically was the fact that Governor Cooper and Dr. Mandy Cohen have said over and over again how effective face coverings are. And he said, well, heck, the bowling alleys say everyone in the alley is going to wear a face covering. So doesn't that in and of itself address much of your concern?
Yeah, that's a very good point. And what happened here was, and this is why the standard of review is so important. If this was a rational basis test case, the judge wouldn't have been willing to do that. He wouldn't have been willing to look at any kind of evidential factors on either side. But because he was applying this, what we call an intermediate standard review, that he did. He looked at the evidence and he said, well, since the government isn't willing to do it for me, I'm going to review the factors that Mandy Cohen said were important here. And I'm going to look at what the bowling alley is proposing to do. And I'm going to see if there's some kind of a rational basis here. And he found that there was. I mean, if there's some kind of reasonable response here, and he found that there was. So that's once again shows the importance of the tests that they use. In many ways, cases like this are won or lost at the very beginning when it comes to convincing the judge what's the appropriate standard of review.
I'm actually going to read, we've been talking about this, but I'm going to actually read from about the middle of the judge's ruling. This is at the end of page 19. It says, the court's decision to grant a tailored preliminary injunction, that's what's happened in this case right now, the injunction against the order allowing the alleys to reopen. The court's decision to grant a tailored preliminary injunction is founded upon plaintiffs' claims brought pursuant to the fruits of their own labor and equal protection clauses of North Carolina's Constitution. So we've already mentioned that, two key pieces of the Constitution. As to those claims, our appellate courts require that the court, meaning Judge Gale's court, conduct an evidentiary review when measuring the reasonableness of the governor's orders rather than presuming their constitutionality until plaintiff has rebutted any conceivable rational basis upon which those orders might rest. So basically that succinctly states what you and I have been discussing.
Right. That's the kernel of the whole case. And I highlighted that one too. He really sums the whole thing up right there.
Now, we could get into more legal nuances, but probably people will be tuning out in a little bit. At this point, this decision with the temporary restraining order allows the bowling alleys to move forward. I understand Governor Cooper and his legal team have already said they're going to appeal. So it's possible that as this moves forward, one of the higher levels of courts would decide, no, this should be in the governor's court. There's no reason for the court to step in now. Would that be, in your view, a mistake? Has the judge gotten this right, do you think?
Well, I was a little bit surprised to see it. He hasn't always decided cases this way in the past. He's looked at some previous challenges to some of these orders, but I certainly think it's the right decision. I did want to make it clear to the listeners, though, this is not an ultimate win for the bowling alleys. This is just a temporary order in their favor, and they're still going to have to make their case in full when the case comes to trial on the merits. But I have to say this: the fact that when the time comes to do that, the governor will presumably do what he should have done before and present his side of the case and explain why what the bowling alleys want to do is not sufficient. But the fact that he failed to do that before, I think, is going to mean the trial judge and any appellate judges that look at it, they're going to feel, I don't know, it's just going to tilt the playing field a little bit in favor of the plaintiffs, in my opinion.
Before we wrap it up, Judge Gale also has a series of lawsuits ahead of him dealing with gyms and fitness centers that want to reopen. And I would guess that you would agree with me that it's going to be interesting to see how this particular standard plays out once he gets to those cases as well. Because if he thinks that the fruits of your own labor and the equal protection clauses of the Constitution require a level of review that's not the completely deferential rational basis standard, that could mean good news if these gyms and fitness centers have come up with plans that seem like reasonable ways to deal with the health risks.
Certainly makes sense. I mean, he ought to be consistent in the application of the standard, and I don't have any reason to think he's not going to be. It is interesting, though, that we put judges in the position of having to look at these kinds of I won't call them scientific, but practical proposals and make decisions that are at least somewhat informed by the science of COVID-19 and so on and so forth. That's tough for them. In my view, when we've got a constitutional provision, whether it's equal protection or fruits of your labor, those are the presumption. There ought to be a strong presumption in favor of the plaintiff. You're free unless the state can show a very good reason why not. So the burden should be, in all cases, this is not the law. I want to be clear about this. This is what I think the law should be. The burden should always be on the state to make a clear and convincing case for why they have to infringe on the freedoms in the way they want to. That's just my view.
Well, that's why we work for a freedom-oriented group called the Locke Foundation. Jon Guze, my colleague, is the Director of Legal Studies at the Locke Foundation. Once again, to recap, as we're speaking, a temporary restraining order has been granted for bowling alleys to reopen across North Carolina. Governor Roy Cooper has already announced he plans to appeal that ruling. So by the time you see this, it's possible that there may have been more court action. And as these cases continue, I'm sure we'll be turning once again to Jon Guze for more of his expert legal analysis. Jon, thanks for joining us.
Thank you, Mitch.